I'm sorry for not being able to do this live. We tried, we failed, and here we are doing a recorded webinar because we promised that we will answer your questions. But yes, the result is going to be the same. With me, I have Rachel Bajaj from Bajaj Legal, and I have Ashish Malhotra from Auswide Bias Agency. Rachel is a solicitor who is an expert in wills and estate succession planning. So she will be the one answering the questions, and we are just clueless, and we will be asking the questions that we want to know more about and what you asked. So Rachel and Ashish, how have you both been? And yeah.
Everyone, my name is Rachelle Bajaj and I run my law firm Bajaj Legal. We specialize in 3 areas of law: wills and estates, property and family law. So it's been quite interesting experiencing how the 3 different areas of law sort of can integrate with each other, because they do. And you sort of see how wills becomes really important in family law matters, but also with this group with property purchases as well. So great to be here. Thanks, Rahul.
Thanks, Rachel. Ashish, how you been?
I've been good. I take all the blame for not getting invited to the live and starting the live. So sorry, people.
Yeah, it's all on Ashish.
Yes, it's all on
we all
me.
are really good at tech, and Ashish is the one.
I suck at it. But fortunately, I know property, and that's pretty much what I do. However, with so much of wealth generation that we've done in the past, I'd say about 7-8 years, now we need a will to make sure we protect those assets. And that's why we are here today with Rahul, finance champ, and with Rachel, who's wills and estate champ, to answer your queries and a lot of mine too. Thank you.
Great introduction, Ashish. So let's just jump into the questions that we have asked. So the first question that a lot of group members also asked in the forums is that, why do we need a will? What's the importance of will? So Rachel, if you can tell us more about, like, why do we need a will? What's the importance of that?
Yeah, so look, having a valid and up-to-date will is really the only way you can ensure that you have certainty over how you control your estate will be managed when you pass away. It basically allows you to provide for the people that you care about, and also leave particular items to certain people in the family, like jewelry and artwork. Also appoint a trusted person to actually carry out the instructions in your will. And lastly, for some families, donating to charity as well is very important. So if you have certain causes close to your heart, that's the other way that you can sort of instruct your executor as to how you want your estate to be managed. If someone passes away without a valid will in place, according to the law, they are considered to have passed away or died intestate. Now, if this occurs, the Supreme Court in their relevant state or territory can actually appoint an administrator for that estate who will distribute your assets in accordance with the laws of that state and territory. So you can imagine this would be very different to the wishes of the person who passed away.
Yeah.
So it's really the only way that you can sort of solidify, well, this is what I want to happen when I pass. And it's all well and good to be generating all of this wealth. You're buying property, you're investing, you're advising your clients to do so as well. But we need to think beyond that. So you're doing this not just for yourself, you're doing it for your children and your grandchildren and for generations beyond. So we can't just think about today. You have to plan for the future. And having a valid will in place is one of the only things you can do if you have legal capacity as well.
So somewhat the way to how we control the outcome of that, whatever we are doing today, where it's going to go after that. So we have all heard that where there is a will, there is a way, but this is a good segue into what if there is not a will.
Yes.
So I think that answers the question.
Correct. If there's not a will, then there's not really much of a way, unfortunately.
Rachel, on that front, what are the risks of not having a will?
I mean, so the number one risk is, first of all, not having your wishes adhered to. You might want certain family members to receive certain things. You might want to offer more protection to your children or to your spouse that you leave behind. For example, creating a testamentary trust. The other risk of not having a will in place is you are leaving it wide open for certain classes of people to make a claim on your estate. So the Succession Act actually allows certain people to make a claim on your estate. The number one person being your spouse, So I'm talking about in families where, for whatever reason, the person who's passed maybe doesn't want their estate to go to their spouse. Children, grandchildren, siblings, aunties and uncles, even former spouses. That's pretty scary. So if you don't have a will, you're actually making it more difficult for the court to actually decide, well, what did this person want? You're making it very clear. By having a will, you're making it very clear to the people around you, this is how I want my estate to be managed and distributed.
And I heard a case where the person left one partner, moved in with another, and within a month passed away. And the new partner came and actually they took the share that they were supposed to. They were not even married. So is that right, that being with a partner in a de facto relationship may impact your assets as well?
Absolutely. So look, in order to become a de facto couple, you need to be living with each other for 2 years. So the 1 month part, I'm not 100% sure, but it happens. Even living with someone for under 2 years, that person can have the right. So I think one of the questions was the one where they said, I'm unmarried and I don't have kids. Why do I need a will? Well, my response to that would be, you might be living with someone and you had your family as well, like your siblings or your parents, and you might want to give things to them. That person that you're living with when you pass away could make a claim on your estate. And there have been cases of this where even it's actually a flatmate, they're not actually in a relationship, but they've been able to prove that they are in a relationship. So I just feel like without a will, you're making it so much more difficult for the people that you're leaving behind. I think it's important to make it very clear as to who you want your assets to go to. And without that, you're just leaving it wide open.
And
so there were two things that you mentioned in that, which I would like to just get some more clarification about. The first one was you mentioned something about Succession Planning Act. What is that? What does that even mean? Just
so
for
after you, after you pass away, your will, we have this, we call it probate, basically. So that is that the Supreme Court needs to validate your will, needs to make sure that it's a valid will, because there's been other cases where the deceased person has signed the will under duress. So the number one thing we're trying to understand here, did they know what they were doing when they were signing the will? You can imagine that this happens with very wealthy families. So there is a Succession Act that governs this part of the law, and it's specifically Section 57 of the Succession Act that talks about eligible persons who can make a claim on your estate.
Okay.
Look, I've got one question which bothers me a lot, and that's why I've been thinking of will, and that's the only reason rather I'm thinking of a will. What happens to kids if you don't have a will?
Depends on how old they are. So obviously more is going to happen if they're minors. If they are minor children, a guardian will need to be appointed. So they don't go to the state. The misconception I get from a lot of clients is they just go to the state and they go into foster care. No, that situation would only happen if there's absolutely no family member or friends who put their hand up and say, hey, I will look after these children. But the issue for a parent might be, I don't know, say you've got 3 different siblings and say only one of them really you feel will be able to look after your child because they're, for whatever reason, they're older, they're more mature or whatever. If you do not appoint someone as your guardian in your will, all 3 of your siblings can make a claim to look after your kids. So your kids won't go to the state. You will still most likely have some family member or relative take your kids, but you won't have choice as to who. Whereas in your will, you can dictate who, the exact person that you want to take care of your kids.
Okay. Okay. So there was a second point to the first one that I was asking. Ashish, is your doubt clear? Is your question clear?
Yes. Sorry, I didn't realize there were 2 questions. So you
all
forward.
good. All good. So the second question was that something you mentioned about a testamentary will, which leads us to the third question that we have, which is different types of will that we can do.
Yes.
So can you elaborate on that? What is testamentary will and how many types of will are there, and what do they all do?
So there are 2 main wills, and we call them a simple will or a more complex will. So a simple will, I call them the I love you will. If I pass away, I say to my husband, I love you, everything goes to you. And if he passes away, everything goes to our child, and that's it.
Yep.
The complex will is what we call a testamentary trust will. It does offer more protection, especially for families that have a little bit more wealth. I normally say around the 300 to 500K mark, if you have that in terms of investments or assets after your estate has been distributed, so after your assets, your liabilities have been paid off. If you have something like that sitting around and even more, it's something that you should definitely be looking into. There are three main reasons why I say that. So the first one being is if your spouse repartners. So let's say you pass away, and everything goes to your wife, and then after a suitable mourning period, your wife meets somebody else and remarries. What happens to the assets that she's inherited from your estate? In a simple will, it just goes into her direct sole name. And if that relationship was to break down, then your assets would be on the table in those family law proceedings, if that makes sense. There's no protection. If we set up a testamentary trust, it switches the onus from that wife putting the assets onto the table to that partner having to prove why those assets should be included in the family law proceedings. Does that make sense?
Yeah.
So nothing's ever foolproof in family law, but it shifts the onus. So all of a sudden, your wife is now on the front foot in protecting that inheritance for your children. Really, it's for the kids. It's not for some, future spouse.
So is there a recommended way to do this? Do you recommend testamentary will more than a simple will? The complex will more dear than the first one?
I definitely recommend it when there are minor children involved. Especially because with the kids and if the family is younger, there's a lot that can happen in the span of 30 years. So the second reason why I say it's beneficial for especially minor children is you get the $22,000 tax-free income. So let's just say it's assets of $1 million that gets passed over. And it earns 5% return. So it's $50,000 of income generated from that lump sum, as long as the capital is not dipped into. Under the simple I love you will, that $50,000 is taxed under the spouse's individual name. So when they go to do their tax return, even it could push that person up a tax bracket, if that makes sense.
Yeah.
And they're basically paying more tax on that.
Okay.
Now, if there was a testamentary trust set up in place, the trustee can choose to allocate that income amongst the children, especially if they're minors, and they'll get the $22,000 tax-free threshold income for each child. So if you're talking about 3 kids, that's $66,000 per year. That can be the difference between a public or private school.
Yeah.
So that's another really big. So that's why for minor children or minor grandchildren. So for the baby boomer generation, I say it's really important. Like it's important for at least clients to be aware of the tax benefits that a testamentary trust can offer. And I know I'm talking a lot. The third benefit I would say of having a testamentary trust is if both parents pass away, leaving their minor children behind, under a simple will. Even in your simple will, if you've said, I only want my kids to inherit the funds when they turn 25 years old, from the age of 18, they can make their application in court to receive the funds from the age of 18, and you can't do anything about it. But in a testamentary trust, you can control at what age you want your kids to inherit that money. Because you think about very wealthy families, they might not want their kids inheriting until they're 30. It's up to, you need financial advice as well in all of this.
Sure.
But every family's going to have sort of different age limits, right? But with a simple will, it's just 18 and that's it.
I've got a question. So I've heard there's some sort of a timeline to testamentary trust, like 99 years or something. What is that all about?
So it generally, like a testamentary trust can go for 80 years is what we sort of say. So it's multi-generational. It will pass from, so you pass away, it goes to your children, it goes to your grandchildren, your great-grandchildren, and so forth. It's still also advised that when your kids are of age, that they also set up their own trust, so it sort of keeps on going and offers them that protection. That's always important because you got to remember your kids will get into a relationship, and and they would want the assets they receive from their parents' estate to go to their kids and not be involved in a family law proceeding as well. So the idea is it's that each sort of generation needs to be setting one up when they're of age, but that it services quite a few generations over the 80-year period, which is again why it's so beneficial. I mean, what are we doing all this for, right? Buying all these properties, investing, working very hard. You're not just doing it for yourself. And I think it's really important for people to be aware that there are mechanisms in place that allow you to look after your future generations.
And
especially Indian families and Indian culture, where property is such an important part. Like we are so dominant in buying properties. It's one of the biggest markets, be in India, be in Australia, but nobody plans that far ahead that what happens when we pass on.
Yeah.
Like so many family disputes. I imagine every family would have some sort of dispute over some property after a deceased grandfather. This is something that irks me.
And it's actually taboo in our culture to talk about death. And in India, it's very different. The law is different in India. But what I would say to Indians living in Sydney is if most of your assets are here, it's going to go with the Australian law. It's not going to go with Indian law. So you've got to be very careful. As I've just mentioned, there is a Succession Act that allows certain people to make a claim. Even if you have a will, they're allowed to make a claim. That's the thing. So these people have the right to make a claim, but if you have a will in place, it's making it more difficult for those people wanting to make a claim to say why.
Sorry, just 1 second. When you said these people, what do you mean by these people? Who are these people who are making?
I can read it out. So the eligible persons that are allowed to make a claim on an estate, the very first person is a spouse of the deceased, a person with whom the deceased was living with or in a de facto relationship.
Okay.
So I mean, even that category, it could be like a support worker that was living with the deceased, right? Like this is where it gets a bit tricky. It de facto, I mean, it can be. Like marriage is different, you're signing the marriage certificate, but there could be, you could have a flatmate living with you too, right? A child of the deceased, a former spouse of the deceased, or a person who was at any particular time wholly or partly dependent on the deceased. So again, this could be
a very broad category.
Very broad category. This could be a long lost relative that, just calls you up and says, hey, I need some help, can I live with you?
Wow.
A person who's a grandchild of the deceased.
Yeah.
And a person with whom the deceased person was living in a close relationship with at the time of the deceased death.
Not as wild. Grandchild is fine. We can accept that. But when we just mention things like a support worker can do that, who helped you for a while, that's something which is completely insane to me. I would not expect that to happen.
Rahul, this gets very interesting. Let's say a person has got 2 kids and both kids remarry. And now they have 4 grandkids from 4 different marriages of partners. And that's where it gets tricky. Like, it's not easy, right?
Blended families, it gets very tricky.
Yeah, and people who are living here since generations, definitely it becomes complex.
I think it was explaining the plot of Kyunki Saas Bhi Kabhi Bahu Thi. I think that's what happens in that. I remember.
So, one more thing, Rachel. So I'm just interested, right? I know 8 years is too long, but I was dealing with a high net worth client, and they had a testamentary trust for almost 40 years. I think she was 65.
Yeah.
And she said, look, I would lose that in 40 years and I need to buy in another trust now because we repay stamp duty or something. So what does that happen? Like, do we change from one trust to another so it renews for another 80 years?
Generally one person, it's like one person, one testamentary trust for 80 years. So that's why I say when you set one up, and then when your kids are of age, they need to set one up too. So it keeps on carrying forward, and it doesn't really end at that point. Once you pass away and there is a testamentary trust, your beneficiaries will be getting advice from professionals like solicitors, financial advisors, accountants as well. So you would expect that these people will be guiding your loved ones as well, that, it's getting to this point. Your kids have now turned 20 or 25. You need to look at your estate planning protection as well so you can keep it going.
Yeah, I wish if we would have found the right professionals in one go. Like I see even an advice varies a lot between professionals. So just in a nutshell, to summarize, so a testamentary trust generally is 80 years, but it is for one person. The person passes away, the trust completes its duration, and after that, again, the options are going to professional seeking advice or moving that entire portfolio into a different trust for which we pay stamp duty.
So you did mention some, like, what happens when children are involved, minor children. The next question is about that impacts of will on assets and children. So did you cover all the points in that, or what other impacts can there be on children when it comes to wills?
I think we covered the main points, but I would say for children, especially minor children, I think the most important thing is that you're appointing a guardian. So in all of our wills, both in simple will and the testamentary trust will, we always ask who is going to be the guardian for your child if they're under the age of 18. I think that's one of the most important things. Other than that, the testamentary trust will offer them those benefits. It'll also offer them the benefits if they get into a relationship. See, sometimes it's, your child might be 18 when you pass away and they've just inherited millions of dollars overnight. They might not want that. They're living with someone and they don't want the person they're living with to find out that they've just inherited all this money. The testamentary trust offers that separation. It's separating the right to control with the right to benefit, right? So with the testamentary trust, you're appointing, until your child reaches a certain age that you're comfortable, you're actually appointing somebody else to manage the trust. And it just gives that bit of separation. It gives your child that protection because, divorce rate is on the rise. It's giving your child that protection if they just end up being with someone for a little bit and you pass away. They don't need to worry about your assets going to them.
There is another term that I've heard called blood will. And the person who raised it, they said they've got two daughters, one married, one in a relationship. And they said, we won't let their spouse have any share in our properties, and we won't let them sell. So I said, how have you managed it? And they said, oh, we've done a blood will. And I really didn't know what is it, but there's something like that as well.
Sort of. So a blood will is similar to a testamentary trust will. So a testamentary trust is it goes within your bloodline, right? So it's your spouse if you choose to, and then it's your children and your grandchildren and your great-grandchildren.
But as you've said before, it still can be challenged, but the onus is on the other person to prove why those assets should be on the table.
Correct. And you got to think, so if this comes in front of a judge at the family court, that person is trying to put a claim through that they want the money. Well, the judge is going to see that you set up a testamentary trust, and it's going to make it very difficult for them to want to break that trust. And that's why it's just giving that extra protection. It's not foolproof, but it's shifting the onus.
Right. Another question that I think is most important, and we've covered a little bit of part of that, is who is the most eligible person who's next to kin?
The first eligible person is your spouse, especially so if you pass away without a will, it's your spouse, and then it's your kids. If there's no spouse, then it goes to your kids. If there's no kids, then it goes to the parents, if they're surviving. No parents, then your siblings. And then I believe after that, it's cousins and aunties and uncles.
Okay. And I think, Rahul, there was another question, who can make claim on our properties? But I think Rachelle has covered in a long sentence. And I'm amazed because in our old age, we generally have support workers working with us. And sometimes if there's a disability involved, those support care workers are living with us. So if they live with us for 2 years, for example, they can come and make a strong claim to our
Look, it would be very hard for them. It's not going to be easy. They would have to give evidence that they were in a relationship.
Let's not give them ideas.
It's not going to be easy, but there have been cases where it's happened.
Yeah.
So my thing is, do you prefer to just have a 100% peace of mind, or and think about what you're doing to your family that you're leaving behind. If someone does try and make a claim, like it's a very stressful process for your kids and for your spouse, and it's a lot, especially when they're already going through that grieving process. So it's be very hard. And you do have to meet that criteria. But it's possible.
It's possible, yeah. We don't want a woodworker coming here, writing a will in blood and be like, yeah, this is a blood will now. You have to give us part of your...
This is one of the best and interesting seminars that I've done. I don't know about you.
Makes you think a lot about your situation as well, that what if your property is like under a trust, which there is like this is personalized thing. I don't want to ask that because it's a very like, my situation sort of a thing. So we will like, we had a lot of questions about that what happens if I have kids and this kid is in this country, this kid is in this country, who it goes to. And I have not included those questions in this because we will just ask them to get in touch with you directly because it is more of a personalized approach. A custom solution is needed for that.
Yes.
So yeah, we will put your intro and we will ask at the end of the session how they can get in touch with you. But I think this covers these points, and we can just ask about the other property side of things, which maybe you would like to.
There was one thing, I just wanted to talk about joint tenants and tenants in common.
Yes.
So this is especially, I have a case at the moment with a blended family situation. So when you're buying property in Australia, you have two ways you can buy it: joint tenants or tenants in common. Joint tenants means it's a right of survivorship. You own the property 50-50. If one of you passes away, that share automatically goes to the surviving spouse. It doesn't go in accordance with your will, right? Tenants in common means you actually have the choice of not owning it 50-50. So you can own it in different shares like 80-20, 60-40. But some families choose this option for tax benefits. But tenants in common goes in accordance with your will. So I have a blended family situation at the moment where the couple that I'm dealing with have kids from previous relationships, and this is now their second or third marriage, and they're together. They own several properties together. They're all joint tenants. So they've come and told me, also, I want to leave. The father has 3 girls, and I think the mother has 2 boys from another relationship. So they both said, we want to leave things to our kids. But I've looked at their assets and I said, but it's all joint tenants. So it's not actually going in accordance with your will. It's going directly to the spouse, your surviving spouse. And how can you trust your spouse will do as you ask? You can't rule from the grave. You can't pass away and then tell your wife, you have to give half of this property to my child. And then, of course, there's, oh, no, she won't do that. But I see how people change when someone passes away. And it's not even that. The surviving spouse is under no obligation to hand anything over. So, yeah.
Sorry, I'm sorry to cut you off.
No.
I get so excited listening to these questions. So, and can someone change from tenants in common to joint tenants and vice versa?
Yes, you can. From memory, if you're going from joint tenants to tenants in common, you can change with no stamp duty, but other way around, there will be stamp duty.
Wow. Okay.
Yes. Yeah.
Interesting.
So, there is an additional question which is not mentioned here, which I just thought of when we were mentioning that they made this mistake. So what are the common mistakes that you see people making when it comes to these things? Either when it comes to buying property initially, which they can avoid if they know that this is a pitfall that they should not fall into. What would be those mistakes? And even for making wills, what sort of mistakes do you see people are making?
So when I have clients who own several property, like this blended family situation I just told you about, the mistake I see is that they're not able to see things from a bigger perspective. Yes, it's all well and good you're buying properties and things, but think about how you're buying it. Because if you're buying it as joint tenants, I mean, normally in a family, you'd want everything going to your spouse anyway, but you need to also consider the protection of how trust can also support the family as well. So not thinking sort of broadly about what are you actually creating here, like a roadmap. Even when it comes to the will, I mean, the biggest mistake is DIY wills, post office wills, like, no, absolutely not.
Okay.
I mean, for a will to be valid, it's simple for a professional like us, but you wouldn't know. So it has to be signed correctly. It needs to be dated, and it needs to be witnessed by 2 people over the age of 18 who are not mentioned in the will. So if any of these things are not followed, it's an invalid will.
And if someone takes an advice from an unsolicited person who is not licensed to give that advice, and people get burned by that advice, do they have a claim anywhere, or this? No?
It's very hard. It's never black and white.
Yeah.
My advice is always, please get advice from a professional in that industry. So, I'm a lawyer. I know how to do a will, I know how to do property law, family law, but if I need financial advice, I'm going to go see a financial advisor. I'm not going to do it myself. And a lot of the times it does blur, it does. But at the end of the day, like if I'm doing wills and property, I do it day in and day out. So I know what I'm doing, just like how I would expect an accountant or a buyer's agent. You know what you're doing, you do it day in, day out. I'm not going to take that risk in trying to do it all myself. I think one of the issues these days is we just wear too many hats. And people don't want to pay sometimes.
Yes.
And I understand, but you get what you pay for as well.
Yes.
And you got to look at the long term. You got to look at the benefit that's providing you and your family in the long term. Because we all have our education in our respected industries, right? We do it day in, day out. We know what we're doing. And that's what people are paying for.
So when you mentioned that something that they can just go and make the wills in a post office, are those people qualified to do that? First of all, is my question. That whoever is
it's a do-it-yourself will, first of all. So it's just a kit that they purchase. And I believe that there are instructions. I'm not purchased one myself. I believe that there are instructions. But the problem is people don't follow those instructions.
It's like reading a recipe and making it yourself after that.
Well, yeah, I mean, it's so easy to forget an ingredient, right?
Yeah.
Again, that's why I say, like, it's see a professional in that industry. Because
that's the thing with our Indian community as well, that they would try to save $500, $100, $200, and would rather risk whatever their $1 million, $2 million portfolio, or even a smaller than that, whatever that amount is. So for such a small amount, I mean, it's not worth it.
It's not worth it. No. Yeah. Especially if it's going to be made invalid. It's defeating the purpose of the entire thing anyway. You want to sleep at night knowing that you've done it correctly and that that's the way it's done and your family's going to be protected. Because isn't this why we're doing all of this anyway? We're doing it for our family. We're doing it for our spouses. We're doing it for our kids.
Yeah.
What is the point of doing all of this, but then not putting that effort into seeing a professional in that industry?
100%. I mean, I'd rather spend $500, $600, $1,500, whatever it takes to prepare a will than seeing a support worker or an auntie get it from
I know. And that's the thing, like these cases exist. Like probate law is one of the most interesting areas of law, you know, and it does happen. The craziest things can happen. And the one thing I've seen is when someone passes away, people just see green in their eyes. You can't trust anyone. If you want certain things going to certain places, you need to see a professional and get that written down.
100%.
And Rachelle, in your experience, would you, I know you've covered one scenario already, which recent one you're dealing with. Would you like to cover any scenarios that have caught your attention that, you know, no one could have thought this, but this has happened? Anything else came across your desk?
Oh, you're making me think now. I mean,
putting you on the spot.
Look, I think for me, the one that shocked me the most was I was dealing with a young gentleman who had passed away and he was in a new relationship, talking a few months. They were living together and he had siblings and he had his parents alive. And obviously his family was thinking that, you know, they were going to take over the estate. And the person that he was living with made a claim and they were very upset by it. Because they barely knew this person, this girl who was living with the deceased. I mean, it was just shocking for me that someone that, you know, was barely part of the family could still do such a thing. And all she's done is gone to see another solicitor who has said, yes, I think you have a right. Let's try and do something. It's just surprising that people just see green. You know, they don't care about the grieving, the feelings. They just want a quick buck. If they can get a quick buck, they'll do it.
So that's the last question from group member, and she's asked that what is the difference between trust and individual will? Which one is beneficial for us Indians living away from our broader families? Thanks in advance.
So trust in a simple will. Look, I don't think it's really about
individual will. Is that a term? Is that a thing? Individual will, or I think she meant
it's simple and complex. If I've
simple
understood
and complex,
correctly,
I think it should be simple.
Okay.
And complex would need a testamentary trust, is what. So I think I can understand the question now.
Okay.
I think it's not really about being Indian. It's more about the kind of assets that you have. What kind of assets are you building? What kind of property portfolio are you building? If it's something that you're building, you have quite a few, that's when you need to consider more asset protection. So I don't think it's really linked to being Indian or not. It's just more about looking.
I think what she means in this context is that imagine if most of the families is in India, and they are moving here, and they have built a portfolio here, and rest of the family is in India. And maybe they don't have children here, maybe just family, parents, whoever they are back in India. So that's the context I think this one is in.
Right, okay.
Which one would be better? Would it be a simple will that can just mention their names, and after I pass on, my assets are going to go away to are going to be distributed in my parents, XYZ family back in India? Or do you think a testamentary will would be better?
Again, I think it's looking at the assets that are there. I think testamentary trust is really going to be beneficial if you have minor kids. I think if you don't have minor, if you're living in Australia, you've got your assets here in Australia, but most of your beneficiaries are in India. Look, I would have to look at that on a case by case, but I think unless you have minor kids, or unless maybe you're in a relationship that you're not sure about, perhaps a simple will might be more beneficial in that regard.
Got it. So most of the cases, if you have minor children, that is a rule of thumb that testamentary will would be a better option for you.
Minor children, or if you've got minor grandchildren, so for the baby boomer generation too.
Yep. So wherever minors are involved, testamentary will would be a no-brainer. That's what you should be going for.
Yeah.
If it's just no minor children involved, then probably you can think of having a simple.
And also remember, even if you don't have kids, but your siblings have kids, you might want to set up a testamentary trust for them.
Yeah. Okay.
Until you have your own kids, and when you have your own kids, then you redo it and you set it up for your own kids. But because it's so beneficial, those tax, especially if they're all living here, the tax benefits, and it can be the difference between a public or private school.
True.
Yeah, exactly.
Yeah. School fees are expensive.
That reminded me of a dialogue. See, मैं तुझे अपनी ज़मीन जायदाद से बेदखल कर दूंगा. Now I understand it better. But I got one question. So most people are now sitting at 3 to whatever number of properties. I have my own 7. I'm a bit worried now. If I have to move everything to a testamentary trust through a complex will, and I hope I'm terming it correctly, do I need to redo and pay the stamp duty again?
No. So with a testamentary trust, it starts on your death.
Okay.
It stays dormant in the will, so we draft the trust into the will, but it remains dormant until you pass away. So
which means the properties can be simply moved in as a diseased estate and no stamp duty is paid. Awesome. Okay.
Sorry, if I'm understanding this correctly, so let's say if someone is buying properties under a family trust, discretionary trust, is that like extend to testamentary trust or will? Or is it a completely different subject?
Two different trusts. So generally what happens is it depends on what kind of family trust has been created. It depends on what's written in the deed. But generally, if it is a kind of family trust that doesn't dissolve upon the death of the member, both trusts will operate side by side.
So Rahul, if
whatever is not in the family trust will then go, all other assets will go into the testamentary trust upon their death.
So Rahul, if I understood that correctly, just in a nutshell, which is how I explain insurance as well. So a will is something that you only need and it gets triggered when you are not there. So before that, you can have property either in trust, personal names. That's a separate thing which gets talked by accountants and all of that. But when you are done, that's when all the properties are moved under that trust protection. So no one else can have a claim on it.
Okay, so we can still have like parallel trust going on, and in the will we can get that whatever is in this trust can go to this person, this property can to this person, and it's just gonna translate to that.
Yeah, so whatever upon their death, if there's a trust there, a family trust there, whatever is left over, whatever assets are left over, that will go into the testamentary trust. And I'm also talking about cash and super and life insurance, which these days life insurance is quite a lot of money. So even if there are other properties owned in other trusts, that's fine. There's everything else that's also there that can go into the testamentary trust.
Okay, makes sense. Yeah. Now, I think we have covered all the questions that we have. Ashish, do you have any more questions?
Absolutely not. I would like to thank Rachelle. And I get really excited when I learn something new.
I'm glad.
Death excites. Any sort of mention of death excites Ashish.
Look, anything I learn, I love learning. It's one of my core values, right? And I believe this will add a lot of value to a lot of people we work with.
Yes.
And because the pure idea of these things is education. So
It is.
really, I'm looking forward to just sending this to as many people as I can so they learn more. And Rachel, if someone needs to get in touch with you, how can
Yes.
they get in touch?
They can give me a call or they can send me an email, which we can share my details somehow.
I'll pop into the video
Yes,
here right next to your
pop
picture.
that in. Perfect. But I also wanted to thank the both of you as well for this opportunity, because I'm all about educating. And as you can see, even the both of you had some aha moments, right? Like it's things I see day in, day out, but other people just don't know. And it's so important. That's one of the reasons why I started my firm. I wanted to just share this knowledge and educate people. It's not about forcing people to do anything, but it's just saying this is how it is here. So you should be aware, you know, so that you have peace of mind.
Thanks for sharing all the knowledge with us. And I'm very, very sure that people in the group will really appreciate that. So thanks a lot again, Rachel. Thanks a lot, Ashish, for taking time for this.
Oh, always for you. And for the group members.
Yeah.
Awesome.
Sounds good. Well, thanks for this.